Good afternoon, ladies and gentlemen. My name is Adrian Meyer, and welcome to The Future of Europe, the show where we discuss complicated legal topics with graduate students. I have the pleasure to be joined by our EU law specialist and graduate student, Stanislas Jarry. Hello, Stanislas.
Hello, Adrian. Thank you for having me, and please call me Stan.
Of course. Today we are going to talk about judicial independence within the EU, and specifically the case of Romania, which, like others, has been facing these problems for many years now. And the recent case of the CJEU on this matter is the perfect occasion to reflect on the principle of judicial independence within the EU. Now, Stan, could you briefly depict the situation of Romania to our audience?
Well, as you rightfully mentioned it, Romania has been facing problems regarding judicial independence for many years now. We've seen concerns about political pressures where judges have been facing political pressures regarding particularly public cases. We've seen examples of corruptions or threats against magistrates, and we've even seen some biased political reforms that try to modify how judges were appointed.
It's kind of like the situation in Poland, right?
Yes, exactly. And the CJEU already ruled in that case that it was jeopardizing this fundamental principle, which is in EU judicial independence.
And what about the threats against magistrates? Yes.
Well, again, you wouldn't say that judges can be impartial where they are facing threats and they are directed to rule in a certain way. So this would, question the whole point of judicial independence and the functioning of the judiciary.
And before going into the details of the case, could you define what judicial independence is?
Well, in order to efficiently approach the notion of judicial independence, we have to divide it in two ways, an external and an internal approach. The external approach refers to the absolute autonomy any jurisdiction must be able to enjoy. And on the other hand, the internal approach of judicial independence refers to the absence of any interest any judge must have regarding the case it is asked to handle.
And how was judicial independence jeopardized in this case specifically?
Well, it is very complicated, I will admit that, but I will try to break it down for you. The case is about claimants seeking damages and seeking to challenge the excessive duration of criminal proceedings. And so the referring court, in order to rule on that action, decided it had to investigate the legislation that governed the SIIJ. But you may wonder, what is the SIIJ?
I do.
The SIIJ is a section for the investigation of criminal justice in Romania. It is an institution that lies within the High Court of Justice and Cassation of Romania. And some of the provision of the SIIJ allowed sanctions to be opposed to judges in case they did not conform with the case law of the Constitutional Court. So the referring court showed confusion regarding which norm to apply, either the well-established case law of the CJEU, which is to let national law unapplied in case of conflict with EU norms, but the other option was to apply the Constitutional Court precedent of Romania, which recently rejected a plea of unconstitutionality regarding articles and provision of the SIIJ.
And in this case, how did the Romanian government try to defend itself?
Well, the Romanian administration actually used an argument that we, as law specialists, seen very often in case of disputes between between states and EU law. So the Romanian administration affirmed it applied EU law with what we could say is a very extensive approach, because the Romanian constitution has been considered to comply with EU law. So the Romanian administration thought that any norms which would comply with the constitution would comply with the EU law requirements. And so the Romanian administration affirmed that the provision of the SIIJ were complying with EU law because they were complying with the constitution of Romania.
Right. So, and in a sense, you may more or less say that this is sort of a shield versus a potential test with EU law. And how did the CJEU interpret this? How did they rule on the case and what did they think about the Romanian government's
Well, as we could all expect, when it comes to the primacy of EU law, the court is not ambiguous. The court affirmed in this case and reaffirmed the principle that EU law prevails even in the case of constitutional norms. So it goes back actually to the principle laid out in Handelsgesellschaft case, International Handelsgesellschaft in the 1970s.
And is it reasonable to think like the Romanian government in this case? Do you think this indirect control of conventionality is a good way to evaluate the compliance of a norm with EU law?
I think it's not very an efficient way because it showed some weaknesses. It's not because a norm complies with the constitution that it automatically complies with EU requirements. And this case is a mere example of why this reasoning is not efficient in our legal framework.
And would you not prefer a strengthened mechanism that would provide better help? And by help, I mean guidelines and so on. And to countries that struggle regarding their compliance with the EU acquis.
Yes, and this is actually a very interesting question because Romania is one of those countries that has been struggling for many years with complying with the EU acquis. We can think of Hungary, we can think of Poland. These countries have been struggling for many years. It is not new, and yet we still are facing cases where action are brought before the CJEU because these states do not comply with their EU acquis and their EU requirements. So it is reasonable to question the strength and the efficacy of our mechanism, of our compliance mechanism. Maybe we could try something different. Maybe we could try using Article 258 of the TFEU and start imposing sanctions, or 260 of the TFEU. This could be a possible solution, an hypothesis to help, to help compliance.
As you know, and I was thinking about this in a sense because we're currently, these countries have to comply with EU acquis, but when one country wants to join the European Union, they need to comply with the EU acquis. So, in a sense, would you not be saying that why force certain countries who want to join the European Union to comply with these acquis when countries within the European Union aren't necessarily compliant?
Yeah, absolutely. And we could easily oppose that to the EU. We could easily oppose them that the reason why Ukraine is not part of the EU is because Ukraine has a problem regarding the functioning of the judicial system or executive system. One of the main elements that is oftenly referred to is corruption. And we are being extremely strict with countries that what we could call corrupted countries that want to access the EU, and yet we let member states facing these issues for many years now. So this might be a good time to rethink our compliance mechanism and to start seeing things in another way.
But do you really think it's the EU's role to investigate this as a sort of supranational authority and assert whether a country's institution complies or not with these EU requirements? Is there not some would say an intervention in national affairs in this case? Well,
I wouldn't want to get too political, but what I would reply to you is that the EU remains a system member states largely benefit from, and the best example of that is the UK. The UK serves sadly as the mere example that the EU remains a legal framework that we benefit from, and an institution and way of functioning that still benefits to member states. So it's not really about whether it is the role or not of the EU, because at the end of the day, if member states are being imposed sanctions or are being progressively restricted in their maneuvers, it is because they agreed to it. So I wouldn't say that the question is about is it EU role or not.
Yeah, they chose to be part of the EU. Yeah. Okay. Well, thank you very much, Stan, for your insight on this very interesting case and the future of Europe in a sense. Thank you very much, ladies and gentlemen, for joining us this week. Don't forget to like the video and join us next week for more of The Future of Europe.